Welcome to a fresh episode of Legal Wrangle, where we will be analyzing major judicial developments in the recent fortnight in the field of taxation. We present indirect tax cases, including 2 each from Central Excise and Service Tax and 1 each from Customs and VAT. The brief facts of this case are that the assessee firm had cleared mobile phone batteries and LED bulbs upon payment of excise duty at the rate of 2% and 6% respectively, and then sought to avail exemption benefit under notification number 12 of 2012. The revenue contended that differential duty was in fact payable by the assessee firm at the rate 10.5% and 6.5% respectively upon the 2 products cleared. In pursuance of such order, the assessee's premises were visited by officers from the anti-evasion wing in order to secure the payment of such differential duty. According to the revenue, the assessee admitted its liability to pay differential duty and so tendered 5 undated checks towards payment of the same. The assessee, however, claimed otherwise and alleged that the anti-evasion wing officials conducted a search of the premises, seized some documents and then collected the 5 undated checks. The assessees subsequently filed a writ petition highlighting the irregularities committed by the revenue and also seeking to prevent the encashment of the checks. The High Court admitted the assessee's writ and directed that the checks be produced in court and also directed that no coercive action be taken against the assessees. Later during hearing, the Counsel for Revenue was unable to draw attention to any legal provision, notifications or circulars which sanctioned the collection of undated checks by revenue officials.
Upon considering all submissions, the court held that it was extraordinary for revenue officials to wield such wide and sweeping powers, enabling them to collect duty purported to be differential duty on the spot without even quantifying the demand amount through service of an show cause notice. The court further held that since this practice had no legal backing, it was inexcusable. The court also questioned why the undated checks had been retained by the revenue officials. The court deemed such practice as illegal and warned of serious ramifications if such practice was allowed to continue, such as a scenario where unscrupulous officials could ask for an amount of evaded duty as a bribe and waive off interest penalty in return. The court painted another grim picture of an assessee being compelled to pay supposed differential duty in cash or check as part of some illegal duty demand, which the assessee otherwise would not pay or be required to pay. All this would harm not only the general public and innocent persons, but also the state exchequers as well. The court held that the officials of the anti-evasion wing had to function within the 4 corners of the law. The court proposed that measures be taken to end such practice.
The facts of this case are that the assessee was an importer of medicaments which came packed in large master boxes. Each master box contained several smaller packages which contained vials of the medicine. The assessee would open the master box, take out the vials from the smaller cartons and paste a sticker on them, mentioning details such as details of import license and price, and also cautioning the user that the medicine was for use by animals only and not for human use. The assessee would then repack these labeled vials and sell them. The department, relying on Chapter Note 5 of Chapter 30 of the Central Excise Tariff Act 1975 with heading Repacking from Bulk Pack to Retail Pack, opined that the aforementioned process amounted to manufacture and so imposed the duty demand upon the assessee. When the matter first reached the tribunal, it was remanded, with reliance being placed on the Supreme Court judgment in Commissioner of Central Excise, Mumbai versus Johnson & Johnson Ltd, along with directions stating that mere relabeling of goods in question without repacking them from bulk pack to retail pack would not attract liability under Note 5 of Chapter 30 of the CETA. On de novo proceedings, the Commissioner appeals dropped the duty demand imposed on the assessee.
Upon hearing the departmental appeal, the tribunal noted that the assessee's activity was only limited to relabeling the vials and the activity of repacking from bulk pack to retail pack does not exist. The tribunal further stated that the Supreme Court in the aforementioned judgment had observed that conversion from bulk pack to retail pack was a must so as to deem a product to be manufactured goods in terms of Chapter Note 5 or Chapter 30. Thereby, on such reasoning, the tribunal upheld the impugned order and dismissed the departmental appeal.
The assessee firm in the present case was engaged in the manufacture of detergent cake and powder. Since the goods were being manufactured with the brand name of Messrs. Ghari Industries Private Limited, the assessee paid royalty charges along with service tax for use of the brand name. Subsequently, the assessee availed VAT credit of the amount paid as service tax. Later, the assessee firm merged with Messrs. Ghari Industries Private Limited in fulfillment of an order of amalgamation passed by the Allahabad High Court. The revenue then took a view that according to the High Court order, the two entities became one, and so there was no warrant for payment of royalty by the assessee, and the invoice for such payment became infructuous for the purpose of availing VAT credit. Thereby, revenue denied VAT credit to the assessee.
The issue at hand arose owing to the order of Allahabad High Court giving approval of amalgamation of two units from a retrospective date. Nonetheless, during the disputed period, tax was duly discharged by the assessee. Thus, tax paid on input service was correctly utilized by the assessee, and the same was not disputed by revenue. The tribunal observed that it was unclear as to how a later order passed by the High Court could make a tax paid invoice as infructuous, and that such reasoning adopted in the impugned order was legally unsustainable. It further held that where service tax had been paid on the taxable service availed by the assessee and the credit was also duly availed within the scope of SENVAT Credit Rules 2004, a later development based on different proceedings under the provisions of company law, cannot make duly paid service tax avail credit during the material time as improper.
The petitioner in this case was engaged in the activity of repacking of muriate of potash on behalf of some exporters who allegedly exported the said muriate. When the department launched an investigation into said exports, and show cause notice was issued to the petitioner. The petitioner later challenged the order in original before the Commissioner Appeals, alleging that no personal hearing was granted and written submissions were not considered before imposing penalty. However, the petitioner overshot the limitation period for filing appeal before the Commissioner Appeals, following which the appeal was dismissed. However, the petitioner contended that the delay was yet within the condonable period.
The High Court relied upon a decision of the Supreme Court to hold that under Section 35 of the Central Excise Act 1944, the Commissioner Appeals was not vested with the power to condone delays exceeding 30 days and upheld the impugned order in appeals. The High Court noted that the petitioner approached this court only after rejection of application for condonation of delay and not by invoking its writ jurisdiction on account of breach of the principles of natural justice. Thereby, the petitioner all the while intended to prosecute the appeal under Section 128 of the Act. The court further held that if this trend was allowed to continue, it would get inundated with petitions coming from parties who did not file appeals on time, which would slowly erode the status of the High Court as a forum for hearing appeals involving some questions of law and instead turn it into a platform for entertaining time-barred appeals. Although the court emphasized upon discouraging such a practice, it did state that it was not averse to entertaining such appeals as long as there was some merit in them. The court also suggested that appeals such as the present one would more appropriately be filed before the appellate tribunal, which was better suited to look into such cases. The petitioner's appeal was dismissed for non-maintainability.
The assessee in this case sought refund of service tax paid under the heading Works Contract Services for various works executed by the assessee for the government of West Bengal and its various agencies, such as supplying of pipelines for water supply, sewerage lines, etc. The assessee claimed to have no tax liability for these services and filed refund claims. However, the assessee's claims were rejected on grounds of unjust enrichment, alleging that the assessee had already claimed abatement and also for the claims being time barred. An appeal by the assessee before the appellate authority too did not bear fruit.
Subsequently, the tribunal agreed with the assessee by holding that service tax had indeed been paid mistakenly. It was noted that the refund claim was denied on the ground that it was partly barred by limitation beyond the period of 1 year from the date of deposit of service tax, supposedly evident from GAR 7 challans. Tribunal held that limitation under Section 11B of the Central Excise Act would not be applicable in case of payment of tax mistakenly. Further, the principle of unjust enrichment would not apply in the case of composite contract price as applicable in the present case. Hence, the assessee's appeal was allowed and refund directed to be granted.
With this, we wrap up this episode of Legal Wrangle. Until next time, keep watching TIOL Tube for our upcoming educational video series Learning Curve. Thank you and have a good day.